Important Bar Rules Series.
Criminal Procedure.
Fourth Amendment. The Fourth Amendment protects the right to be secure against unreasonable searches and seizures. And no warrant shall be issued except upon probable cause. Search. A search is an intrusion on an area in which a person has a reasonable expectation of privacy. A search without a warrant is presumptively unreasonable. Reasonable expectation of privacy. Whether a person is subject to a search depends on the totality of the circumstances. Intrusion on the home and curtilage, meaning the area immediately surrounding the home, constitutes a search. However, a flyover or an inspection of an open field is not a search. Sensory-enhancing technology that is not generally available to the public is not allowed. Dog sniffs conducted in public transportation areas are allowed, but a sniff at the home or curtilage is considered a search. Warrant. A warrant shall not be issued but 1. Upon probable cause, and 2. Must be issued by a neutral detached magistrate. 3. Describing with particularity the place to be searched and the items to be seized. The warrant must be issued prior to the search. Exceptions. A warrantless search is allowed under certain exceptions. Search incident to lawful arrest. A search made 1. Pursuant to a lawful arrest may be conducted. 2. Within the wingspan of the arrestee. 3. In order to protect the officer from weapons or to prevent the destruction of evidence. When the arrest is made in an automobile, the officer may search areas that the arrestee might access or search for evidence of the crime of arrest. Plain view. Police may seize evidence in plain view without a warrant if 1. They are lawfully present in the location, and 2. The incriminating nature of the object is immediately apparent. Automobile. Due to the mobile nature of an automobile, an officer may search a car if there is probable cause that the automobile contains evidence of a crime. If the driver is arrested, the car may be impounded and searched at the station. Consent. Police may conduct a warrantless search if a person with actual or apparent authority consents, and the consent is voluntary. Officers need not inform the person of the right to refuse. Exigent circumstances. Police may conduct a warrantless search under exigent circumstances if they have probable cause to believe that the search is necessary to prevent 1. Imminent destruction of evidence, 2. Imminent injury to persons, or 3. The escape of a felony suspect in hot pursuit into particular premises. Stop and frisk. Terry. Officers may stop and question a suspect based on reasonable suspicion of criminal activity, supported by specific and articulable facts. If they also reasonably believe the suspect is armed and dangerous, they may conduct a limited pat-down for weapons. Seizure. A person is seized when, under the totality of the circumstances, a reasonable person would not feel free to leave. A seizure without a warrant is presumptively unreasonable. Arrest. A warrantless arrest in a public place is permitted if 1. An officer witnesses a crime or 2. Has probable cause to believe a felony occurred. In a private home, an arrest generally requires a warrant and reasonable belief the suspect is inside. Fifth Amendment. Under the Fifth Amendment, no person shall be compelled in a criminal case to be a witness against himself. In Miranda, the Supreme Court held that statements made during a custodial interrogation are inadmissible, unless the defendant was given Miranda warnings and waived his rights. Waiver. A waiver must be made voluntarily, knowingly, and intelligently. Silence is not a waiver. Custodial. A person is in custody if a reasonable person would believe they are not free to leave. Interrogation. Interrogation is not limited to direct questioning. but includes any words or actions likely to elicit an incriminating response. Exceptions. Miranda warnings are not required for questioning reasonably prompted by a concern for public safety. Additional Fifth Amendment rights. Right to counsel. A defendant must unambiguously invoke their Miranda rights. Silence alone is insufficient. Once the right to counsel is clearly invoked, all questioning must stop. Due process. To be valid, a confession must be made voluntarily, based on the totality of the circumstances. It must not be coerced. Identification, investigative lineup, under the Due Process Clause. To the states under the 14th, the federal under the 5th, lineups must not be conducted in a manner that is 1. Unnecessarily suggestive or 2. That provides a substantial likelihood of misidentification. The defendant has no right to counsel under 6th during an investigative lineup. Confrontation Clause. The Sixth Amendment gives the accused the right to confront adverse witnesses and compel the testimony of witnesses. Under Crawford, the prosecution may not introduce testimonial statements by a third party against the defendant unless the declarant is available for cross-examination. A statement is considered testimonial when the circumstances indicate that the primary purpose of the interrogation is to obtain evidence relevant to a prosecution, rather than to address an ongoing emergency. Exclusionary rule. Evidence obtained in violation of the Fourth, Fifth, and Sixth Amendment rights is excluded. Fruit of the poisonous tree doctrine. Additional derivative evidence obtained as a result of unlawfully obtained evidence is also inadmissible, unless the prosecution can establish an independent source, inevitable discovery, or purged taint. Impeachment. Derivative evidence is inadmissible against the defendant, but may be used to impeach the defendant, but not to impeach other witnesses. Good faith warrant exception. The exclusionary rule does not apply if an officer acts in reasonable reliance on a facially valid, but ultimately faulty warrant. However, the good faith exception does not apply if 1. The affiant knew the affidavit supporting the warrant was false. 2. The magistrate's reliance on the affidavit was unreasonable. Or 3. The warrant was defective on its face. Violations of Miranda. Statements obtained in violation of Miranda are inadmissible, but may be used to impeach. Derivative evidence found in reliance on the statement is admissible, unless the statement was coerced.